get started with them, but I understand you have a motion you wanted to take up outside the presence of the jury.
Yes, Your Honor.
Go ahead, Ms. Conrad.
A couple of things I wanted to address with the court prior to starting trial today. The first thing I wanted to address is an issue with the juror that was ultimately that we moved forward with trial after the juror had issues with transportation. I just wanted to put on the record that the juror that was removed is the only juror within the panel that was of Asian descent. My client is of Asian descent as well. That was something that I think is stressed within the importance of some of the case law, that when you look at kind of having an appropriate cross-section of our community, and having someone who can be representative of the defendant as well. I think it's embedded within our constitutional rights. So that's an issue that is important to our client. We wanted to address it with the court and just put that on the record. I know that the court has already made a ruling with that regard, but that's just something I wanted to put on the record.
I don't know what the nationality or the racial background is for the juror that was not able to be here. I can tell you it played no role in my decision.
Totally, and I don't think that's what that's not what I'm implying at
No,
all.
but I think I need to put that on the record.
Of course, Judge, and I understand that. I mean, we obviously didn't even know when he wasn't here who it was.
Right, I didn't want you to know who it was.
Correct.
Because in some ways it shouldn't make a difference.
I agree. I mean, it gets back to the discussion that we had earlier, which, I'm even hesitant sometimes to say of Asian descent, because then I'm looking at an individual and judging them by, who they appear to be to us as well. It's a very weird discussion, but it's something that the case law has brought up in Washington State. I mean, you have a number of cases that stress the importance of. I mean, it's typically with an African American defendant having someone of the BIPOC community within the jury, and so it's something I just want to address with the court and put on the record.
Okay. Is there anything else we need to take up before we resume?
Yes, Your Honor. There's a couple other matters. So the other matter it's been brought to our attention, is something that we dealt with, I think, in court on Monday, and I think that we're getting back to this involvement in the public during testimony. There were a couple moments when there were people in the public that were laughing. I've been told that there have been comments that are being made that are loud enough so that I can hear some of them at counsel table, and so I just ask that we I know this case is important to a lot of people, and so I'm asking that we just that the court admonish the public again to remain professional and courteous during the proceedings.
Everyone should.
Thank you.
Certainly agree with that. As I mentioned, this is not a television show. This is, one hopes, sober and serious proceedings to make a very important decision in our community. And so nobody should try to influence the jury in any way whatsoever, except as within the bounds of the rules of this court. So, anything else we need to take up?
Briefly, Your Honor.
Yeah, I had one other matter, and it's with regard to the admissibility of some of these medical records. So the state and the defense were discussing whether there would be a stipulation to some additional medical records, as well as medical records that have already been read from during testimony. So there's really two sets of records, one that have already been read from, and a second set that have been mentioned during testimony. I think Dr. Stankus mentioned her review of the records and what they indicated. And I've cited to the court RCW 1096030. I printed a copy of it as well, with regard to the admissibility of medical and business records without the need to call a custodian and I don't know if the court remembers, but we had previously provided.
This came up like a month ago.
Correct.
Yeah,
And we had previously provided notice in September with affidavits that meet the standards of 1096-030 to the state. And that statute specifically says if you're going to object to it, you have to do so in a timely amount of time, a timely period, so that the other party can address it. We haven't received any objection, and it calls for a written objection as well. And so that waives any objection to the admissibility of the records. So what I'm offering at this point are the records, and what I tend to do is offer the records that have already been read into the record by witnesses, as well as some of the additional records that just on their face bear relevance to the issues presented in this case as well.
I have no idea how to respond to that. I don't have an exhibit number that you've got in mind.
Okay.
You're going to have to identify what the exhibit numbers are, and then we can talk about it. Because then they get an argument about what was talked about and what was not, or what is relevant or not relevant. Without a concrete exhibit number, I have no way to make a ruling.
That makes sense. So I will gather up the exhibits then, and then maybe we can have a more fruitful discussion, because you're right, that makes more sense that you know.
Now, you
exactly.
indicated there was going to be discussion, and I imagine there has been some discussion with other counsel about all this, and you've evidently been unable to reach an agreement. Is that what you're saying?
That's, yes.
Are you able to reach an agreement as to anything?
Nope.
Great. Ms. Eakes, you rose for a moment. I take it you wanted to say something?
I did, but we can wait until he identifies them. This is the binder full of records that they want to have admitted. The state does have objections, but I'll wait until they provide the court with all of the numbers and all of the exhibits, and I'll make my argument then.
It's a very slim binder compared to all this other stuff we've got here.
Well, I would say it's double-sided records, so it's several hundred pages worth of records.
Okay.
I can get the exact page count the court wants, but it's several hundred pages.
No, I was just happy to see it was as relatively small as it was, because given my prior experiences in this case. And my experience as well, the medical records themselves can be quite voluminous, because they take records of all kinds of things which may or may not be particularly important to us, but certainly have important for health monitoring purposes and so on. Anyway, anything else, Mr. Conrad? You can certainly bring that back up when you actually have the exhibits numbers in hand.
That's what I'll do. I have them listed out, and I'll just gather them up to the court so that we can go through them together.
Great. Ms. Bremner, did you want to add something?
I actually don't now, Your Honor, thank you.
Okay. Anything further from anybody?
No, thank you.
Okay. We'll just await the appearance of our
Okay,
last juror.
okay.
Sorry, Judge. There was an exhibit that we received this morning that I'm not sure what the state's intent is. I received it like 8:30 this morning. It's a National Law Enforcement Technology Center
1995.
bulletin from 1995 regarding positional asphyxia and sudden death. I don't know what the state's intent is, but we might as well address it now on the record before we get started today.
I haven't seen it, obviously.
Can you hand it out?
Your Honor, before we address it, if we're going to address it now, I'd ask that the witness be excused from the court, and while we do so, please.
Okay, Mr. Nielsen, would you excuse us? Okay.
Your Honor, the state's intent is to see what the witness how he answers specific questions, and if he answers them
inconsistent with what the position is and what the trainings are on positional asphyxia across the board in law enforcement, and we may utilize it. Otherwise, we won't. But it's from it would qualify under the learned treatise to be able to, that's from a reliable publication, and it's an authoritative publication, and it would be used on cross-examination versus direct examination. It's actually a publication that Mr. Ryan testified about in his direct, and it's widely accepted across the nation from law enforcement and it's consistent with, what Defendant Burbank was taught also in North Carolina, and what we've been told by Mr. Hicks, that all of the defendants the other two defendants were instructed on here, so. I would expect that Mr. Nielsen's testimony would be consistent with these principles, and if they're not, then it may be
So evidence going to be called to his attention. So, any comment about it? Does it matter that this article seems to acknowledge excited delirium as a real event?
Your Honor, in 1995, excited delirium was accepted within, as, not accepted, it was a concept that law enforcement was struggling with. But
Right.
positional asphyxia is,
Does that have any effect on all of this?
no, it's not strictly tied to position, to excited delirium. It certainly uses it as examples in there, but it's not strictly tied to excited delirium.
Okay. You want to know what they wanted to use it for? Now you know. Is there anything else you need?
I'm sorry, Your Honor, I didn't hear what you said.
I said you wanted to know what the state wanted to use it for. Now you know. Is there anything else you need?
Well, I don't know if it qualifies. I'm looking through the learned treatise under 803.
I'm sorry,
Under 803, and I don't see how it qualifies. It's a bulletin. The other issue, it's from 1995. So, roughly, 25 years prior to this incident, the development within this area has been significant over that period of time. I'm not sure the witness is even aware of this, could comment on it. I also don't believe that it was ever shown to any of the defendants.
I guess we'll have to see.
I think when I'm looking at the tag notes on this issue, it says that the person offering it has to show still that it's authoritative, and that has to be done through the testimony. It could be done through the testimony of another witness, or even on judicial notice.
Your Honor, on cross-examination, it requires that we generally consider it authoritative, and it is from the U.S. Department of Justice, subdivision of the National Law Enforcement Technology Center and the National Institute of Justice Program. There isn't, I'm sure defense would agree that that would be an authoritative agency. And the principles outlined it are consistent with what is being taught today. If you know, like I said, it depends on where Mr. Nielsen goes in his testimony.
I take it, though, this has never been presented to Mr. Nielsen before, during a deposition, or otherwise.
Not during his interview, Your Honor. And I know, I saw him reading it this morning, but, and this isn't, you know, direct examination is different than what you're looking at on cross-examination, so you wouldn't have had to rely upon it for cross-examination purposes.
Now, obviously, I'm just looking at it now for the first time. I don't see anything here that seems to me to be particularly surprising. Except to suggest that or to state that sudden in custody death is not a new phenomenon. It can occur at any time for a variety of reasons. That any law enforcement agency may experience a sudden in custody death. And while rare, such deaths appear to be associated most often with the following variables. And it lists those. Although I suspect that that's not an exclusive list. But I don't see anything particularly extraordinary about it. I don't know that it's even necessary to ask him about this particular document to get to this topic. But I don't necessarily know whether or not how it's used at the moment is going to be improper anyway. So I don't see any reason why Ms. Nicolavo can't ask him about it. All right, so we'll keep you posted as to when we have all of our jurors. Thank you. we left off and you were doing your examination.
Good morning.
Good morning again.
Again, yes. I'd like to start by showing you what's been admitted as Exhibit 301. It's been admitted for illustrative purposes, so we can use that to talk about the use of force in this case. So if we could bring up 301. What is this?
I'm just waiting for it to come up here.
Is it coming up for you?
Yeah, it just came up. This is the first page of the Tacoma Police Department use of force policy.
And did you rely on the Tacoma Police Department use of force policy and the procedures?
I did.
Informing your opinions, of course.
Correct.
Is that right? So what do we see here in terms of this kind of ladder on the exhibit?
My recollection is that there is one of these graphics for every kind of level of force I think that the policy contemplates.
Okay.
And
go ahead.
Sorry. This is basically a kind of a graphic depiction of some of the concepts that we talked about before in the relationship between the force or the resistance being offered by the offender and the force options available to the responding officer.
I don't know if you want to tilt the monitor a little bit towards the jury. It's
Sure,
up to you,
thank
Ms.
you.
Brown. Up to you, Ms. Bremner.
Thank you. And we're going to go to the next page, and I'm going to ask you, about like that, Your Honor?
Well, you may want to pull it out just so you,
Can you help me?
I will. Chris, or excuse me.
Thanks.
From the base.
You might.
there you go.
Thank you.
Then they can't see the witness as well, but at least they can see the exhibit.
Thank you.
You can tilt it back a little bit when afterwards, or you can have Mr. Nielsen come out here.
Come out this way a little bit.
That's okay, sure.
Thank you.
Yes.
So what do we have here?
This is the second page of the Tacoma Police Force Manual. Much of this verbiage is kind of the preamble. It involves the philosophy, some of the circumstances under which force may be used,
Okay.
and then it goes into the definitions of some of the terms that you'll find throughout the remainder of the policy.
Okay. We'll just leave that for a minute for the jury to see. And then if we can go to the next page, please. What do we have there?
This is the third page, and this is a continuation of the definitions that are used throughout the rest of the policy. We've talked about neuromuscular incapacitation or neuromuscular control, for example. That term is defined here. The concept of necessity, which quotes the statute that we talked about earlier.
Right.
That's also defined here. Talks about the reasonable officer standard, the threshold for a reportable use of force. I think we talked about sometimes, depending on policies, force may be reportable or not reportable depending on the severity or the circumstances.
Right.
So it talks about that. It defines serious bodily injury, and et cetera, et cetera.
Okay. And then at the end, it talks about compliant cooperative controls. Is that right?
Correct. Then it moves into the next portion of the policy. Yes, and that portion is labeled compliant cooperative controls.
If we could move to that, please, the next page. So is this a compliant chart, basically, for what kind of force, if any, can be used when someone's compliant?
Correct. Yeah, and this is the first, I think, of three that I noted. And like I said, each level of force that's dictated in the Tacoma policy, from what we could call, I guess, the least severe to the most severe, will accompany one of these. Will be accompanied by one of these graphics here. I can talk about the graphic in detail if you like, or however you want to.
Please, I mean,
Okay.
not for too long, but
Yeah, no,
just give an overview. That'd be
Yeah,
great.
sure. And we talked about earlier the concept of kind of modulation of force depending on the resistance being offered by the offender.
Right.
And when you see these steps here, each step on the left side of the graphic depicts the conduct by the person with whom the police are dealing. And that ranges from the bottom with compliant conduct and goes up to the most severe, which is life-threatening conduct. And you can see this arrow here that is has arrow indicators at both ends, indicating that the subject's behavior can move up and down between these forms of resistance. On the other side of the graphic, the right side, you see force options going from the least restrictive, which is cooperative controls, to the most restrictive, which is deadly force. And so these steps get progressively high and low. And again, there's an arrow indicating that these options can move up and down in correspondence to the resistance being offered on the left side of the continuum here. And you can see there's arrows kind of going back that depicts the relationship between these two. So this graphic is meant to inform officers of their options and how they're supposed to respond directly in relation to the resistance they're getting from the subject.
If we can go to the next page. Now on this one, what's highlighted in terms of the type of resistance
Now,
encountered?
and as we talked about, there's one of these graphics for each level of kind of resistance here, and this one indicates it's under the classification of active resistance and corresponding force options. So you see that active resistance is kind of the mid-level resistance that you could get by a subject, and then compliance techniques are the class of force options that would be available to the officer under the Tacoma policy.
In this case, was this a case of active resistance, at least vis-a-vis Officer Rankin?
Yeah, vis-a-vis all, yes.
And vis-a-vis all the officers?
Yeah.
There's a higher level there in terms of resistance involving assaultive behavior, is that right?
Yeah, and again, depending on whose version of events that you take to, that you believe, it may have risen to that level at some point during the encounter as well.
All right. So if we could just talk about right now the active resistance. Can you tell us what that is?
As we talked about before, at the bottom is compliant, and so, for example, if I say face away from me and put your hands behind your back,
Right.
and the person does it, that's compliant. Passive resistance would be face away from me and put your hands behind your back, and they just stand there and don't do anything.
Okay.
Or maybe they sit down on the ground and don't do anything. And then active resistance would be pulling away, trying to escape, pushing and running, like that kind of stuff.
And so what kind of force can be used with somebody that's actively resisting?
This is kind of a broad category too, because the intensity of the active resistance can also vary. And so,
Okay.
for example, if I grab someone's wrist and they just kind of pull away, that could be. But if they really thrash around and try to run, that could be another level. So there's kind of variance in that classification. So the use of force is also going to vary depending just how active the person is resisting.
Okay, before we go to what kind of force can be used, can you talk about this case, again, vis-a-vis Officer Rankin, and what he encountered in terms of that kind of resistance?
So when Mr. Ellis was restrained on the ground, he was in handcuffs, and he was, my understanding is he was, according to the officers, was flailing around and kicking, and kind of, one of the officers said, he was kind of like wiggle worming his way toward traffic, like those kinds of things. Now that's not passive conduct, that's active conduct. He's actively kind of thrashing around trying to thwart the officer's ability to restrain him further or to transport him or whatever their next step was going to be. So that's active resistance. Even though he's handcuffed, people can still actively resist. That's not, it's a fallacy otherwise, right?
And they can use other parts of their body, of course.
Oh yeah, they could spit, kick, headbutt, all that kind of stuff.
And they can get up, right?
They could, sure.
So in this case, was there any concern about whether or not Mr. Ellis had a weapon?
My understanding was that once Officer Rankin arrived on scene, he was unaware of what had preceded his arrival.
Right.
I think he was aware that there were mic clicks. There was a, kind of
But I'm
a.
going to object. This has actually been asked and answered and addressed last time.
Overruled, you may continue.
I'm sorry, Your Honor.
Overruled, you may continue.
Thank you. Go ahead.
Excuse me. My understanding is there were mic clicks. There was I think it was Officer Burbank that called out their location in kind of a very breathy, brief radio transmission.
Right.
So he was aware of that. When he arrived on scene, I think he saw that both of the officers, Collins and Burbank, were both fatigued. Mr. Ellis rather was face down on the ground, and like I said, the officers were winded. I think he saw he got a firearm magazine, a handgun magazine on the ground. Right. So those are all things I think that he was made aware of, or he was aware of when he arrived.
And did he know who the magazine belonged to?
Well, my understanding at that time, he didn't.
And was that a concern that there was a magazine on the ground?
I think it would be for many officers that arrive on scene. I think if you arrive to a scene where a person like that was fighting with that kind of vigor, and there's a firearm magazine on the ground, you would definitely have to account for that somehow. I think account for the possibility that it belonged to the person with whom they were struggling.
And there was a pat-down in this case, or a sweep for weapons. Did that occur before or after Sergeant Lim arrived, within 26 seconds of Ford and Rankin?
Yeah, my understanding is that Officer Rankin arrived. Officers Collins and Burbank were then kind of relieved and moved away from the area, and then he almost immediately rolled him onto his side and checked for weapons.
So
I think that happened before Sergeant Lim got there.
if you could go back then in terms of Exhibit 301, can you tell the jury what kinds of, let me get back to this in my iPad, what kind of first electives are allowable under the use of force procedures and policy of the Tacoma Police Department with this kind of resistance?
So, with active resistance,
Subject, Your Honor, vague as far as, is it in general, or is it this type of resistance that Defendant Rankin was facing? I mean, he testified
No,
earlier.
I agree. Could you make it more specific? Is resistance at what point in time?
I'm just asking, Your Honor, generally, and that was my, I was a little bit too broad. Under the policy and procedures, can you tell the jury what kinds of responses are allowed in terms of force when you've got an active resistant suspect?
Your Honor, it's the same objection.
Your Honor, it's in the policy.
I'll permit this.
Thank you, Your Honor.
the way that the TPD model, the Tacoma Police Department use of force policy is modeled is that every level of resistance kind of incorporates the prior level of force options. So down below here under heading 2 where it says enforcement electives, it incorporates all cooperative controls, all contact
But
controls.
I'm going to slow you down a little bit.
Sorry.
Let's start with the first one. What is that?
Yeah, okay. So all cooperative controls would, like I said, when you have a cooperative suspect, that's a pretty low maintenance police event. If the person's cooperating, there is generally no force that's required to be used because the person's cooperating. So compliant handcuffing would be a good example. So if
Okay.
the person faces away from you, puts their hands behind their back, you move your handcuffs and you put them on the person, that would be a cooperative control because the person was compliantly handcuffed.
What's the next one?
Contact controls for enforcement electives, so that moves up to, so passive resistance, there's a kind of a close relationship between the controls for passive resistance and then the lower level active resistance.
Okay.
Okay, so for example, if the person is just sitting on the ground passively, not following your commands, they won't stand up, walk with me, you're under arrest, kind of thing. Then again, it's a pretty low force moment where you could pick the person up, right? You might grab them by the arm, grab them by the wrist, you might underhook their armpits, you might get a fellow officer, grab their feet and their armpits and kind of carry the person. And, it's not a highly technical process if you're just trying to carry somebody into a car. You have to account for their safety, account for the safety of the police officers, right? So if you move to a different position where maybe they're upright, and they're kind of pulling away from you a little bit, again, you might grasp the wrist, or the wrist, you might apply like rotational pressure, so the person has to kind of like follow your commands because their arm is bound up to the pressure you're applying. So those are kind of contact control type things, and those are incorporated in this active resistant level of force. So it could be that you would respond to a higher level of force that you would kind of, for lack of a better term, maybe under-respond. So you might try to apply rotational pressure to the person's wrist before you go to a higher level of force, just to see if that works. And that's contemplated in the policy, that you would include that force option in a more kind of serious event, if you will.
Okay. And what's the next one?
And then it lists, so then we're at active resistance, and so then it lists a whole host of force options that are available for this particular classification of resistance.
Go ahead.
Yeah, and it would include the taser, so the electronic control device. It would include the 40 millimeter launcher, which would probably be commonly known as like a rubber bullet, or sometimes they're like foam, like a racquetball, maybe like a little more firmer than a racquetball. That would be a 40 millimeter extended range tool. It's fired from a shoulder-mounted platform.
Shoulder.
Sorry, shoulder-mounted, like a rifle kind of. And again, control techniques. So that could be maybe strikes. It could be holds. It could be, again, like I said, like rotational pressure, joint manipulation, that kind of stuff. Neuromuscular controls, which again is closely related to the taser, so that could be like a contact.
I'm sorry, sir.
Sorry.
Can you please slow down?
Yes, I'm sorry. It tends to be a. Sorry. Okay.
Start at the beginning.
Okay. Neuromuscular controls. Then the next is OC, chemical application. So OC is pepper spray. Other chemicals might be like tear gas, but that would be kind of a different circumstance. Leverage tools, which again is like joint manipulation, applying. These are kind of hands-on type maneuvers, and so again, it could be rotational pressure, it could be joint pressure, those kinds of things. Arrest tactics is kind of a broad umbrella term for a lot of these other things that we talked about here. Canine, search development of canines, so bringing in a dog to search. That is a use of force because the way that canines are trained in this particular region is that they're contact canines, and so they'll find and bite and hold. Most are, some people just bark. But many will find and bite and hold. That's a use of force. And then takedown techniques. So that could be basically classic techniques that would involve taking the person from a standing or a kneeling position to the ground. And there's a whole host of techniques you could use to achieve that.
Can you give us some examples of those techniques? Maybe a couple?
Like just to talk about it, to tell you about them?
Yeah, takedown techniques.
Sure, like the classic would be like a double leg takedown, like a wrestling takedown, right? Where I would shoot down on the person's legs, secure them, and kind of tackle them to the ground. That would be the most
Okay.
kind of like rudimentary one.
Okay.
There are other ones where you might like grasp the person's wrist and maybe their upper tricep, so the person would be like this, and then you could apply like rotational force, and that would cause the person to go to the ground. You could do that. They're like shoulder lock type moves where I might lock the person's shoulder up and I could use that same motion to take them to the ground, or I could take them the other way so they would go back to the ground. You would use their momentum and the inertia of the encounter to take them to the ground.
And incidentally, you talked about some statutes. I'm going to let you sit. Please just stay there for a second. With respect to the statutes you talked about on assaultive behavior on Collins and Burbank, were those felony statutes or misdemeanor statutes?
Well, an assault by definition on a police officer is a felony.
Okay, is
So
that assault 3?
That would be assault third. So if you spit in the face of a police officer, by statute, that would be a felony.
And the reason I ask you that is because the next level is assaultive behavior. Is that right?
Yeah, that's correct. And on that term, that reasonableness still applies. And so if you spit in the police officer's face, that doesn't give the police officer carte blanche to start pummeling the person. It still has to be reasonable. And so even though there's a higher level of force applicable, like if someone, opening hand, or pushing, if you push a police officer, that's an assault too. Assault as well.
Right, not assault in second.
Right, not assault second. But that doesn't give the police officer carte blanche to start hitting with a baton or, so there's this relationship between the level of assault. If you punch me in the face and break my eye socket, that's a much more serious event. That would give rise to a higher level of force options for the police officer. And that goes back to this relationship on this graphic here.
And also, with respect to the officer's firearms, is there a concern about a suspect getting their firearms?
Oh, yeah, definitely.
Can you talk about that,
Definitely.
please?
There's kind of an axiom in law enforcement that every conflict that you get in, right, you bring an event to the fight. And that's every time the officer shows up, officers carry firearms, and so when you put hands on people, they put hands on you, you always have to account for the possibility that you could be disarmed. And so police officers are trained pretty extensively on what we call weapons retention techniques. So weapons retention.
It's hard, your back.
I'm sorry. And so there are lots of options for the officer, some options I should say, for the officer to take active measures to retain their gun. But it's always something that's on your mind. Anytime you're wrestling with people, or even for that matter, walking in a crowd, dealing with the public, always mindful of the fact that you have to keep possession of your gun. I mean, there are statistics that's widely cited that when an officer loses a gun, there's a high likelihood they're going to be killed if they were shot with it at least. So
Is there a high likelihood what?
that you're going to be killed or shot with it.
With your own gun?
Correct. So
And-
keeping your gun is very, very important.
And did you understand whose magazine that was at the scene? Was that determined later?
Correct, after the fact. And I think it was Bereng's, if I'm not mistaken.
And in terms of a suspect getting an officer's gun and using it on an officer, Glocks are used by these officers, is that right?
I believe so.
And is there a safety on a Glock?
So most law enforcement policies dictate that you have to
Your
have.
Honor, relevance, there's no evidence that there was even Glock was on the scene, or that a Glock was used, or that the trigger was pulled.
I object to a speaking objection, Your Honor.
Well, I don't have any problem with that particular objection. Yeah, what's the relevance here? Nobody's alleging a firearm was used or displayed.
I'm sorry, Your Honor.
I said, what's the relevance here? There was no allegation here that there was a firearm either used or displayed by the officers, or by Mr. Ellis for that matter.
The relevance, Your Honor, is that the concern of all of these officers is to make sure that they maintain their gun and somebody doesn't get a hold of it, a suspect.
Well, that point's already been made. What does a safety got to do with anything?
Well, I mean, it basically shows how easily it can be fired.
Objection.
Concern on the part of the officers.
All right, I'll sustain the objection.
Thank you. Is there a technique that you use in law enforcement under the appropriate standard practices in handcuffing a combative suspect?
Yeah, there's a few, but almost always combative suspects end up going to the ground in the prone position for handcuffing.
With the court's permission, I'd like to just have him demonstrate how to handcuff a combative suspect and using Mr. Conrad.
I'm going to object to that.
You object to Mr. Conrad?
You object to a demonstration.
I object to the demonstration. If the court wants to hear an argument on it, I'd ask that we do this.
Okay, well, excuse the jury while we have that discussion. Ladies and gentlemen, please do not discuss the case among yourselves or with anyone else.
Sorry, I kept you up there too long.
That's okay. I'm sorry. That's a tendency I have.
Now, if I allow this, can I do it on the condition that Mr. Conrad remain handcuffed throughout these proceedings? Anyway, Ms. Stikalava, you have an objection to this.
Your Honor, there's no relevance to this general demonstration that isn't applicable to what was occurring at the time and the facts that we had asserted by all the defendants on what was occurring. And it's not reproducing, it's basically putting on a theater production for irrelevant purposes.
All right, well, let's,
I mean, you can certainly describe what they're trained to do.
okay, so, Ms. Bremner, what's the point of this?
It's just a demonstration, Your Honor, that this is the jury. It's allowed under the evidence rules. There's a WPI in it. I think it's 6.02. And I think it's helpful to the trier of fact to see how this is done, especially with the criminal charges without restraint on the fact that they've made against my client.
Your Honor,
It's how this is done.
my understanding is she's not going to reproduce what occurred. This isn't accurate for what her client did and the circumstances surrounding it. And the weight, height, everything, just as the court would not allow the state to do the demonstration with Dr. Mitchell. I mean, we went over and over again and the court ruled not gonna allow it to occur.
That had to do with the hobble.
I'm sorry?
That had to do with the hobble.
Yeah, and it had to do with you not able to reproduce it based on the size and makeup of Dr. Mitchell and the circumstances that surrounded it. We're the same exact circumstance here.
Well, I don't know that it's exact.
Well,
Because for one thing, Dr. Mitchell is a forensic pathologist, not a law enforcement officer, describing how handcuffs are applied by law enforcement officers. But
And also,
is there really anything new here? I mean, what's the,
yeah, sure.
I
I mean,
believe she did have Officer Ford describe how they occurred, how handcuffing occurred. He did it right in front of the jury. So it's not a question of how handcuffs are put on.
Your Honor, when, as to Mitchell, of course, was a forensic pathologist, but the other thing was, my client didn't apply hobbles, so it wasn't relevant to Officer Rankin. What we're simply trying to show here is when you have a combative subject that you get on their back with respect to restraining them and putting on handcuffs. I did have Officer Ford use the handcuffs on me, and I think the court probably wouldn't mind if they were stayed on me, just like Mr. Conrad, as you mentioned, but that was just to show how handcuffs work. Okay? It wasn't to show how they were applied in this case or what kind of restraint was used in this case.
Your
yeah,
Honor,
but does that go to Mr. Nicolavo's point that it's been talked about and actually shown by Officer Ford's demonstration? That do we need to do this again?
It's completely different, Your Honor. It's on the ground, it's prone, it's restrained, and it's with parts of the officer's body on the back.
So this is going to be Mr. Conrad on his stomach on the ground?
Yes, he's willing, Your Honor. I checked with him.
Your Honor, again, the pressure that was applied to Mr. Ellis and the circumstances of the pressure that was applied to Mr. Ellis is what's relevant, not what happens here in the courtroom with Mr. Conrad and Mr. Nielsen. I mean, he can certainly describe what they are testified to, what they are taught, and use his words. I know he knows how to use his words up there and describe how it's done, but demonstrate in front of the jury in circumstances that aren't even close to what Mr. Ellis faced in this situation. And last I checked, Mr. Conrad's pretty thin build, doesn't have the same health conditions. The pressure that he feels from Mr. Nielsen is nowhere near what Mr. Ellis experienced.
Well, obviously, this is not going to be an exact recreation of the event. But
Exactly, Your Honor.
I'll permit the demonstration.
Thank you, Your Honor.
And the court let the state know what parameters you're allowing for the demonstration?
What parameters do you want to know about?
Well, when we find out specifically what the demonstration is going to entail.
Well, my understanding was is that Mr. Conrad's going to be at least face down on the ground.
That's right.
And the issue is going to be how do you get somebody handcuffed under those circumstances, which I suspect has something to do with placing your weight on the back of the
Exactly, Your Honor.
of the suspect in order to achieve that.
That's right.
If the court, which the state's still objecting to the court allowing that, I would ask that the court restrict Ms. Brimner from making any comments or asking anything about pressure, breathing, anything of that nature.
Mr. Conrad's not a witness, you're right.
Right.
So questions about that to Mr. Conrad certainly would not be appropriate. To the extent that breathing is an issue that might be of concern to an officer in those circumstances, I'll certainly let Mr. Nielsen talk about that if the question arises.
Understood. Thank you, Your Honor.
And presumably Mr. Conrad's not going to be making any statements or commentary while this is.
He shouldn't. This is not supposed to be his testimony, but how it felt to him.
Right.
So no, he shouldn't say anything
All right.
unless it's to ask Mr. Nielsen or to instruct him how to proceed.
The other question I would have, Your Honor, is when we interviewed Mr. Burns, we were informed that Defendant Rankin actually demonstrated on Mr. Burns, the Rankin's use of force expert, how he put pressure on Mr. Ellis. So I'm assuming that's the same thing that's going to occur here, which is he actually demonstrated both knees on his back and both hands on his back, and his ankles kicked out.
I don't know about that. I mean, I don't know where they're going with this. Obviously, I just found out about this too, so I'm not sure what you expect me to do. I'm not clairvoyant. All I know is that they said they wanted to do handcuffs. They didn't say anything about hobbles. right? So we're not gonna hobble
We're not gonna do
Mr.
that.
Conrad. So obviously, it's not this exactly the same thing, but,
Right.
No, Your Honor, I'm sorry if the court misunderstood me. When we interviewed Mr. Burns, he demonstrated how at the time, Officer Rankin had shown him the pressure that she put on Mr. Ellis, which was both knees and both hands on him. If the
That
court,
didn't-
I just want to make sure the court, I
The
wasn't saying
demonstration-
hobble, so.
We're demonstrating high-risk cuffing, Your Honor, not what Officer Rankin did at the time.
okay. All right, let's have the jury back.
I don't agree with the characterization of what Mr. Burns demonstrated, but if you want to call Kent Booth to the stand and have him testify, you can.
I can't hear you, sir. I did not hear the end of what you said.
So you said if you want to call him to the stand,
Yeah, I mean, I wasn't aware that we were being videotaped also during the proceedings.
Right there, the video of what was happening.
Without our consent.
I don't know whose consent I need to film what was happening.
I don't know what you guys are talking about, but whatever.
Well, I wasn't aware that we were being videotaped during the interview. I don't think that was ever approved.
You weren't physically speaking.
Anyway, that's between you guys. It's got nothing to do with my motion. So,
Got it. Thank you.
great.
Thank you, Your Honor. We're ready.
Let's have the jury. Okay, proceed with your demonstration.
Mr. Conrad's here. Sure. Could you please step down and show on Mr. Conrad how to handcuff a combatant?
Excuse me, a combative suspect?
I'm suspecting that Mr. Conrad is not going to be combative during this demonstration.
At least not right now.
So, would it be more?
Where would you
in
want me?
I hope so.
Or an
No, I
uncooperative or
think-
combative.
take multiple people speaking at once.
I think it would be like a high-risk cuffing situation. is what I would say.
Well, the question, what's your question? You want somebody who's actively resistant? Is that the words you want? Am I looking at the policy? Is that what you're talking about?
Your Honor, that's different than what we just discussed on the record. And even when they do the active resistance videos at the academy, they repeatedly say it's not active resistance because we have the individual just laying there.
I don't know, I'm trying to figure out what her question is, because she was talking about combative, and it seems to me active resistance is less than combative. But I don't know, I'm just trying to clarify the question. I'm not opining one way or another about it. What do you mean to say here, Ms. Bremner? Or ask?
How to deal with an uncooperative and potentially resistant suspect in terms of handcuffing or restraint.
Do you understand the question, Mr. Nielsen?
I do. I think that the technique that we would address doesn't, it would be the fundamental high-risk
Right.
cuffing technique. So it would be contingent on Mr. Conrad not resisting it happening. But the principles of that technique would be, I think, germane to what we're talking about.
Okay.
And Your Honor, if I could just volunteer the witness for a few questions before the court allows us.
You had an opportunity already.
Well, this is different than what,
I don't know that it is. Is there some issue about his qualifications to talk about this?
the question on high-risk cuffing, the individual, which in this case will be Mr. Conrad, will not actually be making any motion of being a high-risk individual. He will be laying there compliant while the witness demonstrates what they would do if it was.
I don't know. I guess we'll see what Mr. Conrad does. And he may well wind up under arrest before we're done.
Okay.
Anyway, let's come on forward and let's ask your question again, and then let's go from there.
Thank you. Can you please demonstrate the cuffing technique with a suspect that's potentially combative or resistant?
Okay, so this would, don't lay down yet. So this would be the principles, this would be the foundational principle, and then moving up from there.
Got it.
So this would be like a high-risk scenario where the person is non-compliant or presents an elevated risk to the arresting officer.
Okay.
And then if we were to introduce measures of resistance, these principles would still apply, and then some depending on the resistance.
Understood.
Does that make sense?
Yes, it
Okay.
does. Thank you. What should he do? Get on the ground?
I think if he does, I don't know if everyone can see in the back.
The jurors
but-
can stand if they
Okay.
care to.
Okay, so let's do this, Mr. Conrad. If you could just take one big giant step back, and then just go ahead and lay down with your head facing me this way, so that we have room. There you go, like angular. Good, and then just sorry, you just moved. Go back to where you were. Put your hands out to your side like an airplane. Okay, ready?
Yeah.
So what I would do is I would approach from an angle, maybe like the 2 o'clock side if I'm going to take his right hand into custody, which I would do. I would bend down, I would scoop it. I would face his wrist away from me, so the back of his hand is at my chest.
Okay.
Okay, I would hold it close, and I would kneel here. And see, I have the option here of modulating the pressure that I put on him. So if he starts to thrash around, I could modulate pressure. I could go heavy, I could go light. I'm not putting any pressure on him now.
Mm-hmm.
But what this position allows, are you okay?
Yep.
Okay. What this position allows is if he can't roll into me, and if he tries to roll away from me, I have control of his shoulder here. And depending on his level of resistance, if any, I can put pressure across his shoulder blade, avoiding his neck. Then what I would do here is with his hand, I would grasp these fingers. And this is when we talked about control techniques. So I can apply pressure here, which is going to bind up his elbow. Are you okay?
Yep.
Your Honor,
And his wrist. So this is so I have him under control here. And once I have him controlled, I remove my handcuffs, and I would put one on here, and I'd say, oh, this way. So that, yep. And I would say, and I would tell him, put your other hand on your lower back right here. Go ahead and do that. And then I would affix the other handcuff. Once he was done, I'd roll him on his side. I'd check for weapons, and then I could sit him up and transport him if I needed to. Does that make sense?
Thank you.
Yep. Got it. Sorry.
With respect to Officer Rankin's restraint of Mr. Ellis, can you tell the jury about the facts with respect to why Officer Rankin needed to restrain Mr. Ellis, as you understand it?
objection, Your Honor. Mr. Ellis was already in cuffs at the time that Lieutenant Rankin arrived.
I didn't ask that, Your Honor.
Well,
I asked
there,
his understanding.
restraint has been broadly defined in our proceedings. So handcuffing alone and hobbling alone may or may not constitute restraint. And obviously, we've got some testimony that there was more involved than just those two things.
Your Honor.
So I'll allow the
For
question.
clarification, The only statement that we have is from Officer Rankin. He obviously doesn't know what was in his mind outside of what was in that statement.
It's evidence in the case, counsel. It's produced by the state, I might add.
Right.
Certainly, Your Honor.
Okay. Proceed.
Thank you, Your Honor. Do you still have the question in mind?
I don't, I'm sorry.
It's all right. You can have her read it back, but I'm not going to torture her anymore. Okay, thank you. Okay. Are you ready now?
I'm ready.
Okay. Can you, what are the facts you relied on in forming your opinions in this case about the necessity of force and the reasonableness of force with respect to Officer Rankin's restraint of Manny Ellis?
My understanding is that Mr. Ellis was face down handcuffed when Officer Rankin arrived. And then with all the other facts that we discussed moments ago, earlier in the testimony. When Officer Rankin arrived, my understanding is that Mr. Ellis was still actively moving around pretty vigorously, from what I
Right.
understand. Kind of thrashing his legs and bucking his hips, things of that nature.
There were two uses of force or two restraints employed by Officer Rankin in this case. Is that right? Two separate times.
Yeah, you could conceptualize it that way, I suppose.
The first would be when he arrived at the scene with Officer Ford and was trying to restrain Mr. Ellis. So let's talk about that one first. What was the justification for restraint in that first use of force or first use of restraint?
So, again, as we discussed earlier, when the police have somebody in their custody, they have a responsibility to make sure that that person is as safe as possible, right? So if he's thrashing around, and I know there was some information that there was the concern of passing traffic, he's moving vigorously, bucking his hips, kicking his legs, things of that nature. And as I said before, if you don't do anything and he starts bashing his head into the ground, right, then the police officer owns that outcome. And so my understanding is that due to the kind of the intensity of Mr. Ellis's bucking around, that the first thing that Officer Rankin did when he arrived was put some pressure on his torso to help mitigate that conduct or help to kind of reduce Mr. Ellis's bucking around.
In your opinion, was that an appropriate and lawful use of force?
I think it was. There aren't very many options for controlling somebody demonstrating that behavior under those circumstances. So I think that of the few options that I suppose you could come up with, that was the most obvious and probably the most reasonable.
And is there a substantial risk of death in restraining somebody on their back?
Objection, Your Honor. This was asked and answered.
We did have some conversation about this yesterday.
I know that I asked exactly this question, Your Honor.
Well, no, but we talked about football players and wrestling and that
We did.
stuff. So move on to a new question.
Can you quantify the risk involved in the use of a restraint on somebody's back or force on someone's back? That's a different question, Your Honor.
I'll permit this. Go ahead.
Can I quantify it?
Yes.
I would say there's been this notion of likelihood, and I
Right.
don't think that it's likely at all. I think it's possible, and at that, minimally possible. But like we talked about before, with uses of force in general, there's always the possibility of injury, but that doesn't preclude that particular force option depending on the circumstances. And so it's exceedingly rare when you put pressure on someone for them to have this outcome.
Exceedingly
Object
rare,
to this.
is what you said?
He doesn't have any knowledge of how often this occurs, and it's outside of his scope of expertise.
I'll allow the answer to stand.
Did you finish your answer? You said it was exceedingly rare for what?
I have done this. I've been in its proximity. I have had it happen to me many times. And the times where you have an outcome like the one at issue here, it's a possibility, and it's one you should account for, but it's not even remotely a likelihood.
It's not even remotely likely, is that what you said?
Correct.
And you said exceedingly rare, is that right?
Correct.
Anything else with respect to the underlying facts for an appropriate use of force opinion in that first use of force that you want to address with the jury before I move on to the second use of force?
No, like I said, the force options available to control that kind of behavior are pretty minimal. And if you're talking about keeping someone on the ground, there is no real practical way of doing that without putting some measure of pressure somewhere on them, depending on the intensity of the resistance.
Now, there was, at some point, Mr. Ellis was put in the recovery position, is that right?
That's my understanding.
And what was the circumstance that came before the placing him in the recovery position?
When we talk about the recovery position, I want to make sure that we're talking about,
Yeah, go ahead.
We're talking about the same thing.
Okay.
Okay. So the recovery position, that entered into law enforcement training, mainly from military training dealing with combat trauma in the field. And if you conceptualize someone like laying in the fetal position on their side, and then extending their bottom leg, right? So kind of if you were like, I don't know, if you were kind of like cuddling a body pillow,
Okay.
like that kind of position. And it came from the idea that if you had thoracic trauma, like a gunshot wound or a stab wound, that would facilitate breathing in the field for the military. That was introduced to law enforcement because law enforcement deals with the same kind of trauma in their day-to-day, kind of activity, both with civilians, with suspects, and then other law enforcement personnel as well. So the recovery position came into law enforcement training under those circumstances from military combat trauma care. And then it kind of was broadened to other circumstances where the person might need facilitation or to facilitate breathing. Okay, but it's also not the only, that kind of particular recovery position, that position on the ground is not the only way that we would care for somebody who had experienced any number of kind of either trauma or injury or a struggle with the police. So there are other ways of doing it also.
Okay, and so what came right before his placement of Mr. Ellis in the recovery position?
My understanding was the progression of events is that once Mr. Ellis, his conduct kind of ebbed a little bit and he was not thrashing around as much, that's when he was rolled onto his side.
Mm-hmm.
Officer Rankin frisked him for weapons, which I think was wholly appropriate under the circumstances.
Okay.
And then when he started, Mr. Ellis that is, started to resist again, Officer Rankin rolled him back onto his stomach.
And were each of these acts appropriate? Putting him in recovery, putting him back on his stomach when he resisted, and then putting him in recovery again?
Well, I think and again, this is in response to the actions of the person with whom you're dealing.
Correct.
And so when that person's on his side, it's difficult to control somebody under those situations. They can roll toward you, they can roll away from you. They probably can't stand up as easy, obviously. But it's hard to control people when they're on their side, and just balancing the human on
Right.
their side like that. And so I think naturally when people thrash around in that position, they would naturally roll to their side, or their stomach rather, when they're handcuffed behind their back. And so putting him in that position until he stopped thrashing around again, I think was an appropriate decision.
And was there, what did Officer Rankin do to show, strike that, what did Officer Rankin do to ensure Mr. Ellis' safety?
Well, I think that again, once the resistance by Mr. Ellis ebbed again, he rolled him back into the recovery position.
All right.
And to me, that shows an awareness of the situation at hand. That shows an awareness that this possible outcome that we talked about could be present, and he's trying to mitigate it by putting him on his side. And also, my understanding was that he checked his pulse. Okay, which again is something I think that I know that we're trained to do under certain circumstances. So he shows an awareness of his, I guess you could say, respiratory opportunity by putting him on his side and then checking his pulse and then monitoring his breath too by also getting down close to him. And I think Officer Ford did that as well. So
Okay.
they're looking at his breathing, they're looking at his pulse, and they kept him off his side when he was compliant. Then when he was non-compliant, they put him back onto his stomach.
Did they also speak to him?
My understanding was that they did, and they were. I think Ford was telling him to calm down, breathe, that kind of stuff too. So to me, it shows a pretty high level of engagement with the person, and a reasonable concern for their well-being.
I don't know if you want to break now, Your Honor, for the morning break.
Well, okay. Take our morning recess now for 15 minutes. Please do not discuss the case among yourselves with anyone else, ladies and gentlemen, and we'll see you back in 15 minutes. violent struggle extreme enough to require the officers to employ some type of restraint technique, drugs and/or alcohol intoxication. And with respect to the cocaine-induced bizarre or frenzied behavior, when occurring while confined by restraints, cocaine-induced excited delirium and acute mental disorder characterized by impaired thinking, disorientation, visual hallucinations, and illusions may increase the subject's susceptibility to sudden death by affecting an increase of the heart rate due to a critical level. But it suggests this whole thing is rare and not just in excited delirium cases. Right? Did I misread any of this?
John is recognized sports for Wayne State has a different interpretation of it. I see it's not gonna change anything, so.
Well, I'll regard that as me having convinced you of the error of your way. Okay, we're breaking.
Thank you, Your Honor.
Bremner?
When we talked about restraint before, I just want to be specific. It's a position restraint that we're talking about from Officer Rankin, is that right?
Correct.
Let's go to the second use of force, if we could, please. After Mr. Ellis was put on the recovery position, he was taken out of that position, is that right?
Correct.
And why was that?
My understanding was that when he was on his side, he began to thrash around again, and they were unable to control him in that position. And so they moved him back to his stomach.
And was that a reasonable use of restraint or force?
I think it was. I mean, that's a pretty low level of force based on what we're dealing with.
And was it a different level of position restraint than in the first use of restraint or force?
As far as the position or the pressure,
Both.
my understanding was the position was similar and the pressure was less.
Position was similar and the pressure was less.
That's my understanding.
Okay. Basically to hold them into place.
Correct.
301 was the exhibit we went through with the different pyramids of force. With respect to the use of force or position restraint by Officer Rankin, was the force or restraint used necessary and not excessive,
Objection
Overruled. You may answer.
in your opinion?
When we discussed active resistance on that stair-step diagram,
Yep.
and then we discussed all the subcategories of available force options.
Right.
There were things like strikes, tasers, chemical irritants, canines, right? And now, again, we have to be reasonable because if he's in that position prone and he's thrashing around, that's active resistance, but you're not going to tase him or send a dog or strike him. That would not be appropriate. And so what he did is he rolled him back onto his stomach. And that is, I mean, there's only a very few ways of dealing with that conduct, and he did that in direct relationship to the resistance he was getting from the person. So, of all the force options that were available, excuse me, this was among the least intrusive, or the least, I guess, risky.
Okay, so, and therefore reasonable and necessary, not excessive. Is that right, in your opinion?
I think so, yes.
Okay. And incidentally, it had Officer Rankin struck Mr. Ellis, kicked him, anything like that, would your opinion change?
Definitely, yes. That would not be appropriate under those circumstances.
And he didn't do that, did he?
No.
Jack Ryan testified in this case about stacking legs. Do you know what that is?
I do know what he was referring to.
What is it?
My understanding is that Mr. Ryan's testimony was that the only viable option was to somehow place Mr. Ellis on his side and sit on his ankles.
Okay. And is that a viable option in your professional opinion?
Well, not only that, but I mean it is, but it's not going to prevent him from thrashing around. And so if the goal is to stop Mr. Ellis from thrashing around, putting him on his side and not having any hip control, not having any shoulder control, and just sitting on his ankles is not going to prevent that from happening.
And then you talked about when one is in a prone position, a suspect, that they should be put in a recovery position immediately. Is that always possible?
Well, I also know that if the notion is, or the idea is to force somebody into the recovery position,
Right.
then you're talking about another level of force justification. So if the person is fighting you, trying to put you in the recovery position, then you have this kind of odd notion of having to use force to put them in a place where you think they should be. And so this would be like, for example, if you had like a gunshot victim with a penetrating torso wound, and you put them on their side, and that caused them great difficulty because of the internal bleeding. And they're fighting you to do that, and you held them on their side because of that would not be appropriate. And so the idea that there is one solution for every situation is just not viable.
And law enforcement restraint and arrest are not static, right? I mean, they're dynamic.
They are dynamic, like many facets of law enforcement, and that's why the standard is reasonableness.
I asked you earlier about the importance of officer safety when you testified on Monday. And I wanted to ask you, in what kind of stops or circumstances are officers most at risk for death or serious bodily injury?
The top three kind of fluctuate,
Okay, go ahead.
and it fluctuates between car crashes, between domestic violence calls, and it's just what you would call suspicious subjects, and that can be a whole variety of different things. But usually it's people like proactive type work. You might be dealing with a car prowler, or somebody who looks like they may have just sold drugs or those kinds of things. And so, like a street contact where you just don't know the person's motive, intent, and kind of desire or capabilities. That's one that the officers are hurt and killed at a lot. But it's those three, depending on the year, they fluctuate between those three categories.
And are you aware of any circumstances where a handcuffed individual has seriously injured or killed a police officer?
Objection, Your Honor,
I'll permit this. It's a use force expert. It actually has been testified by other witnesses in the case, so I'll permit this.
I'm sorry, Your Honor, is the question allowed?
It's allowed.
I'm sorry.
It's allowed.
Thank you, Your Honor. My ears this morning a little bit.
No, I think it's more me than you, Ms. Bremer.
Thank you.
Sorry about that.
Do you have the question in mind?
I do.
Okay. Go ahead and address it, please.
Yeah, that happens, and that happens for a variety of reasons. But handcuffed people can still cause you harm, especially if they're not secured or they've been searched. So there are instances, kind of widely publicized instances, where people have reached into their waistband and produced a gun even when handcuffed, and have shot cops. That happens often, not oftentimes, but when it happens, it's sometimes in the back of a police vehicle. So you have to search people well, is the kind of takeaway, but also handcuffed people can still do bad things.
And I think in 2015 we had an incident with Mr. Ellis reaching into a pocket for a syringe while handcuffed.
Oh yeah, that happened, yeah.
And incidentally, how did the incidents in 2015 and 2019 factor into your opinions in this case?
Objection, Your Honor.
Basis?
Prior rulings for the court, in addition to 2015, it's nowhere.
I don't know. But if it's done as written, maybe it didn't play a role. I'll allow him to answer this question. Overruled.
Yeah, when we talked about earlier about settling on a foundational, like a factual universe, like that helped inform that. That affirmed kind of the facts upon which I was relying to opine.
I'm sorry, I didn't hear your whole answer.
Sorry, yeah, that informed my understanding of the facts upon which I relied to opine on the conduct here.
What does control an assessment?
Oh, that's a good question. So the assess portion, right, is always kind of reevaluating what's at hand. And that can be a whole host of things. And so, for example, if you've been in just in a really serious altercation where there's a vigorous, kind of fight before you detain someone, that could be not only assessing the person, but assessing your surroundings for other things that might happen, other people that are present, other risks in the environment. And so it's kind of a global assessment of dangers to you and then also dangers to the person or risks to the person. And so that concept, the control and assess, it can kind of fluctuate depending on the circumstances. So it could be control and assess your environment for additional threats, like a bar fight, for example, or it could be control and assess the person that you're dealing with. And so once you have a person handcuffed, then you begin to pat him down,
Right.
pat the person
Or her.
down. Yeah, exactly, pat the person down. And then also start checking for injuries, summoning aid, those kinds of things.
And incidentally, did Mr. Ellis have any injuries consistent with Officer Rankin's positional restraint on his back?
Objection, Your Honor. Lack of foundation, this witness is on.
I'm only asking if he knows, Your Honor.
I'm going to sustain this objection.
Can you tell the jury how the suspect, in terms of their behavior, can dictate what an officer has to do in response?
Yeah, that notion or that principle is captured in the graphic that we talked about earlier, and I think it was it 301?
301.
Yeah, and that the police officer's response is always contingent upon resistance that they're getting from the person. And so policing is an inherently reactive endeavor. So you're always trying to kind of gauge what you have and respond appropriately. And that's especially true in force situations, where your force is dependent on the resistance that you're getting.
And have you looked at the PC statement in this case? It's Exhibit 2158.
I've seen it.
Permission to approach, Your Honor?
Proceed.
Thank you. What is a PC statement? I think the longer version is certification for determination of probable cause.
What's exhibit number?
2158.
2158,
2518. Sorry, Your Honor.
2518.
2518. Is that the certification in this case from the prosecutors for probable cause in charging?
Yes.
And is it signed by Ms. Eakes and Mr. Lowe, the prosecutors from the AG's office?
It is.
In paragraph 5, does it reference excited delivery?
Hold on. What's the relevance of this?
The order is admission under 801 by party. They have discounted excited
Your
delivery.
Honor, I'd ask for this to be heard outside the presence of.
I don't know.
Well, she's responding to my question. Can I see the exhibit? What was the page number?
It's paragraph 5, Your Honor.
I mean, of course, there's lots of paragraphs here. I mean, one that's denominated 5.
Yes, Your Honor. Roman numeral 5. No, it's.
That's on page 10, I believe.
2518 is exhibit.
No, you said the rule, mentioned the rule, I thought, or maybe
No, we're talking about the citation, which is what paragraph we were on. And this is on page 10 of the document. Well, I'm going to excuse the jury while I have this conversation. Please don't discuss case, ladies and gentlemen. Be seated, everybody. Well, you're saying this is a declaration by party under 801?
Yes, Your Honor. Let me just pull it.
Of course, counsel is not a party, they represent the party.
But it's also, if I just take a moment, Your Honor, I've got it all right here.
Yeah, where are we going with this? Maybe that'll help determine whether it's even relevant.
I only have one question with this, is whether or not Officer Rankin is charged with not rendering aid or acting appropriately when Mr. Ellis was suffering from a medical emergency, i.e. excited delirium.
Your Honor, there's no relevance at all to this line of question.
Well, I'm not sure I'd say that. I'm not sure this is a relevant piece of evidence with respect to that. I mean, the state says in its declaration for determination of probable cause, beginning around line 9, that the caption of this paragraph is paragraph 5, Officer Rankin. And it says the BLEA, which refers to the Basic Law Enforcement Academy, curriculum includes a course on excited delirium. Course materials make clear that excited delirium is a medical emergency, and that when a subject has experienced excited delirium, officers should, 1, take care to ensure that the subject can breathe, 2, avoid inhibiting breathing in any way, and 3, not put pressure on the subject's thorax or leave the subject face down. Now, I realize that the state has claimed that excited delirium is kind of a non-existent thing, even though they've put this in here. But it was something that also the defense has conceded is something that the City of Tacoma Police Department didn't necessarily adopt. They were still treating excited delirium as a genuine thing. And I don't know that there's anything in here that's inaccurate. There may have been training Officer Rankin with respect to excited delirium. It does kind of trench on this exhibit that was talked about before that the jury hasn't seen yet, that we talked about this morning. Well, what's the point here? Are they claiming that is this an admission that Mr. Ellis suffered from excited delirium? Is that what you're claiming this is?
Right, and that they took the position and charged our client with manslaughter based on their assertion that Manuel Ellis was suffering from excited delirium and it was a medical emergency. They had experts get up and say it's been refuted by the AMA, the American Association of Emergency Medicine, and banned in California, and that it's not an appropriate use of the syndrome in this case, when in fact they charged it.
Well, we do also have some information, do we not, that this diagnostic criteria has been sort of redefined and still exists in some kind of way. I don't know, Miss Nicolavo, what do you want to say about this? What do you want to say about this?
Your Honor, I think it's fully appropriate for this witness to go through this. I mean, it's not a question that's before the jury at all. And this is prior to numerous interviews that occurred. And it continued.
Do you have a different opinion now? Do you want to amend the information?
Your Honor, the declaration for probable cause is what she's reading from, not
Right.
the charges.
No, I understand that, but you're saying that somehow things have different.
Well, there's certainly more information we put in there, but that's not the purpose of a declaration for probable cause. It's a charging document only, which is not a concern for the jurors in this case.
Well, it hasn't been admitted, I grant you.
I'm not offering it.
And in general, well, you are when you say let's read it, and so everybody, you're reading a part of it when you admit it as substantive evidence.
Your Honor, I have a couple of cases on it, but basically, it's a non-hearsay statement of a party opponent. I mean, it's signed by the two prosecutors trying this case, and it's relevant because they've offered a trial of facts completely inconsistent and theories inconsistent with what they stated in their certification, the probable cause. And
Well, I'm not sure I'd say what they've advanced theories that are completely inconsistent with
Well,
it.
it is. I mean, it is inconsistent when they come out and say they don't even allow that it's like some different theory. I mean, their position is it's debunked, it's vacated in California, AMA, emergency medicine, it's not recognized. And so they're basically saying that anyone that says it's excited delirium in this case is wrong, when they're the ones that put it in their certification. And it's their charging document.
Well, of course, that's not all they allege here. At paragraph E, they also allege that Rankine rolled Ellis back onto his stomach from his side. And although Rankine said that Ellis was violently thrashing all over again, they say this is contradicted by observations from two other officers in the scene who were interviewed later that night. Both said that Ellis was quiet and stopped moving after the hobbles were applied, etc.
Your Honor, I could just ask if he's read the document, whether they serve excited delirium.
Well, I have to say this is maybe the longest declaration for determination of probable cause I've ever seen. It's pretty close anyway. It's 21 pages.
Right.
We don't usually see them remotely this long, so there's a lot of detail in it.
And I don't want to
But
offer.
what's your authority that this is somehow an admission by party.
Well, I can actually have this sent as a brief to the court, but I've got the 801 on hearsay, admission by party, and then we go on
Do you
to,
have a case?
I'm getting to it, Your Honor, just one moment, please. I've got it here. So, first of all, it's ER 801D2,
Yeah, I'm familiar with that.
and then going on to the cases in Ray MD, 758 Atlantic 2nd, 27, DC Circuit 2000. I won't cite McCormick and Weinstein.
Wait a minute, 758 Atlantic 2nd, page 2000?
27.
Page 27. It's a 2000 case, year 2000?
That's correct, Your Honor.
Okay.
And also,
The DC Circuit?
yes.
Okay, interesting.
And then the I'll spell this case, BAKSHINIAN. It's 65 Bed Sup 2nd, 1104, Central District of California. Well, numerous courts have applied the party opponent rule to statements by a government prosecutor, reaching that prosecutors are interested parties with the power to bind the government. There's U.S. versus GAF Corporation, 928 Fed 2nd, 1253, Second Circuit. Case
Wait a
91.
minute, wait a minute, 928 Fed Second, what's the page number?
928 Fed 2nd, Your Honor, 1253,
12.
Second Circuit, 1991.
Okay.
This is dealing with the bill of particulars from the prosecutors in an amendment. And going on, court, Second Circuit reversed the trial court, holding that the original bill of particulars was a statement of a party opponent, akin to attorneys' opening statements, and that it was admissible against the prosecution, akin to admissible inconsistent power pleadings in civil cases. And I've omitted the quote from the court. And another case, Harris v. United States, 834, Atlantic 2nd, 106, 2003. And it looks like, again, a probable cause declaration. Decided to admit a probable cause declaration. And
What's the site one more time?
it's Harris versus United States, 834, Atlantic 2nd, 106, 2003.
106? Okay.
Yes, and on this, on appeals of the District of Columbia, the court reversed a conviction, looks like a murder, holding that the declaration was an admission of a party opponent under the Federal Rules of Evidence 801. And this was, again, a request to admit the probable cause declaration in support of a search warrant in that case. So here, the probable cause declaration is clearly not hearsay.
Was it a trial, or was it admitted for purposes of questioning the validity of a search warrant? I can see where it might come in on a motion to suppress a 3.6
Right,
type matter.
right. This was a declaration in support of a search warrant in a murder case where the prosecution had asserted that the victim had conspired to murder the defendant when the defendant was charged with murder. So he sought to use that in his own defense.
At the trial.
Yes. The court refused to admit the probable cause declarations. He was convicted, and it was reversed on appeal.
834 Atlantic 2nd, 106.
Yeah, Harris versus United States, 834 Atlantic 2nd, 106.
Okay.
But I'm not seeking to admit the declaration for the certification.
Well,
But I do
if
just want to make that part.
even if I look at it that way, the statement in question does not say Mr. Ellis was suffering from excited delirium. It actually simply says Mr. Rankine was trained in what to do in the event of such a medical emergency. So
Your Honor, it
where's the
says-
concession?
In paragraph 5, it said that he failed to act appropriately in a medical emergency that was excited delirium. That's the charge.
Well, it doesn't even say that in paragraph 5.
And I'm paraphrasing, but it's basically that he failed to respond to a medical emergency. And the fact is that they've asserted excited delirium in their certification, also dealing with St. Peter's, they talked about it in their cert in terms of their expert opinion, and now they're saying the opposite, in a manslaughter, in murder trial.
I don't think they're saying the opposite.
Your Honor, my position is that they put it in their charging papers as a verity.
I get you. But when I actually look at what is said there, it doesn't say that.
Why cite it at all? If it doesn't exist. Next question.
And the last paragraph of the whole document on page 21. It says the charge of first-degree manslaughter against Rankine is supported by the above detailed evidence showing that Rankine recklessly caused Ellis's death when, after hearing Ellis say he could not breathe, Rankine continued to hold Ellis in the prone position and to apply pressure onto his back. The charge is supported by the evidence that Rankine failed to render or call for urgent medical aid, as Ellis exhibited signs of a medical crisis, failed to alert other officers to Ellis's medical distress, failed to stop another officer from putting a spit hood over Ellis's head, haven't heard any evidence about that, and failed to remove the spit hood as Ellis's condition declined, among other facts and circumstances. So in order for this to work, I've got to let in the statement at paragraph 5 on page 10 about the course on excited delirium and information with respect to what steps should be taken in a medical emergency of that kind, with the statement on page 21 that says,
Oh, go ahead, Your Honor.
well, it says that he failed to render or call for urgent medical aid. And also continue to hold Ellis in the prone position and apply pressure on his back. I got to sort of put those things together, don't I, in order to have this make sense?
Your Honor, I think that standing alone, the fact that they, in the charge against my client, that they charge him with not acting appropriately in a medical emergency, i.e., in the face of excited delirium, should just be standalone, something I can ask, because it's, from my view, completely an opposite to what they put forward here. They're basically saying it's vacated in California. It's been criticized by these national organizations.
Well, I mean, to some extent, this is this is awkward and has always been awkward, and I've struggled with this a bit, and I've sort of said it out loud, but we've got this issue where the state is claiming that the actions of the officers put Mr. Rankine in a position that ultimately led to his death by virtue of the hypoxia and the positional hypoxia and asphyxia and so on.
Right.
There's also information in the case that Mr. Ellis was struggling, that he was acting out of proportion and to the situation. So we have this, and so we have had testimony about his sweating, about his extraordinary strength, about his aggression, and all that kind of stuff too. And some of that stuff is consistent with what has been known and was known, evidently even at the time, at least by some, as excited by delirium. And I'm not sure the state agrees with all of those things. Maybe they agree with none of them. But they do believe that at some point in time, he was placed in a position where he was hypoxic, and that the officers failed to recognize it and take appropriate action. And they claim that that was either negligent or reckless, when we're talking specifically about Officer Rankine and the first-degree manslaughter charge, which of course would be reckless, not negligent. But so how does this add anything here? I mean, I'm not sure there's any. What is the concession? Just that we're giving the name excited delirium?
It's an admission, non-hearsay under 801 from them that they recognize excited delirium. And it's inconsistent with their position with experts. And it doesn't exist. I mean, that it's not recognized, that it's been debunked, that it's not recognized by the AMA, Emergency Medicine, dogs nationally, and vacated in California. So therefore, they've discounted any arguments that this was part of the equation in terms of Mr. Ellis's unfortunate death. And
Why should this come through this witness?
Because he's an expert witness, Your Honor, on use of force. He's also a lawyer who's a prosecutor who's been recognized as cert for probable cause, and also he did review it, relied on it, and he talked about excited delirium at some length in his report, which I'm not going to get into unless we get into this new exhibit, and I have to follow up, because I think it's been addressed sufficiently.
State.
A couple of different things, Your Honor. There's the issue of this isn't an admission for party opponent. If you look at comments and tailings in both 801 and 21, in both civil and criminal cases, parties are allowed to plead.
Are you reading from Tegland?
I am, Your Honor.
Do you have a?
And it'd be page 425.
Thank you.
22, 23 edition.
Oh, good, because I got the new one, but I haven't managed to get it on my bench yet. And so I'm reading from the same page I'm at. So 420.
425, Your Honor.
425. Thank you.
We got when you read.
Let me at least get there first. You're reading under admissions in pleadings.
Correct, Your Honor.
This is page 425. It says paragraph 801 colon 21. Okay, go ahead.
Correct, Your Honor. In both civil and criminal cases, the parties are allowed to plead alternative theories in support of their claims and defenses, even if theories may be inconsistent. Such pleadings do not constitute substantive proof and normally do not constitute admissions by a party opponent. Goes through and cites multiple cases in which that is consistent with. In addition to that, as the courts noted, the section that defense counsel wants to bring in does not state that the state's theory is he had excited delirium. It states that the defendant, Mr. Rankin, was taught about excited delirium. And so if he thought it was excited delirium, which he indicated in his statement that he did, there's certain steps to take, and those are the steps that he was taught to take. In addition to that, there's nothing in the state's probable cause statement or anywhere else that we've acknowledged he has excited delirium. We're not admitting he has excited delirium.
Your Honor,
I would.
It's a bit of brief to the court with the cases that I cited, so I'd like to move on if we could.
Well,
Get the jury back.
then at least for now I'll sustain the objection. I've got a number of citations, which I haven't read, frankly, because he just gave them to me.
Right,
But they're all federal.
right.
And of course, the federal criminal system's a bit different for a number of reasons. I don't know, the context of these particular cases, but most of the time, In federal cases, there is a grand jury proceeding and a number of other things which are a little different here than by charging via information, which is done commonly in the state of Washington. And of course, we do have, whether I haven't read this site either, but we do have the site in Teglin, which specifically refers to at least a state case where the defendant's statement that his defense would be a general denial and or self-defense was not admissible as proof that the defendant committed the crime charged. Because, for one thing, self-defense sort of acknowledges that you did something, but you were justified in doing it, right? So I don't know. So I've got state authority here at the moment that Ms. Nicolavo is citing that seems at least superficially, and I don't know if I read the details of this, I would have a better answer for it, but superficially sounds like she's right. So if you want to move on to something else, that's fine, but for the moment, I'll sustain the objection.
Thank you, Your Honor.
We've got about 10 minutes left. We'll time the jury.
Excited delirium that you were
I did.
and why did you do that?
In large part because there was mention of it in the materials that I reviewed by Officer Rankin, among others.
In a nutshell, what are the signs of excited delirium?
It could be extreme agitation, like sweaty, kind of hyperactivity, like paranoia type behavior. It's a constellation of those kinds of behaviors.
And are drugs associated with excited delirium?
Oftentimes,
Okay. And deaths?
yeah, sometimes.
Finally, under Graham versus Connor and the standards, the factors, can you tell the jury your assessment of the use of force by Officer Rankin in positioning restraint on whether or not he met the factors under Graham versus Connor of objective reasonableness from the view of the individual officer, meaning Officer Rankin?
So, when Officer Rankin, as we talked about, arrived on scene, right, he was unaware of what preceded his arrival.
Right.
What he did see was the officers that were tired, Mr. Ellis continuing to struggle in handcuffs, the magazine from the handgun lying on the ground,
Right.
and then when Mr. Ellis was kind of flailing and bucking around, he knelt and put pressure on him to stop that from happening, right? And my opinion is that was a reasonable response to the resistance that he was getting. it was a fairly low level of resistance, but it was also a fairly low level of force, which corresponds to the resistance that he saw, that he had experienced with Mr. Ellis. And then as you move through that, once that resistance kind of ebbed, and he was able to roll Mr. Ellis on his side and pat him down for weapons, at that point, there was no need to use any more force at that time. And then when Mr. Ellis started to buck around again and move, again, that necessitated some measure by the police officer to control that behavior, which is rolling him back onto his stomach, right? Like we discussed. So when you look at the severity of the crime, at that time it was kind of unknown to Officer Rankin. He didn't know what was going on. But these three factors under Graham are not each exclusive. So you could have an unknown severity of the crime but a very high risk, or you could have a very high severity of crime and an unknown risk. And so you kind of balance all these things and you judge them against the force that was used. So even though it may have been unclear to him at the time what the crime was, Mr. Ellis was clearly detained. He was clearly exhibiting behaviors to try to thwart further detention, right? And the risk was unknown or presumably present because of the presence of the handgun magazine and his behavior after being detained. So you weigh that against the level of force, which is simply rolling him on his stomach and putting pressure on him until he stopped moving that way. I mean, that, to me, is a perfectly reasonable response to that conduct.
Objectively reasonable under Graham,
I believe so.
and also reasonable from the perspective of Officer Rankin.
Yes.
Okay, thank you, that's all I have.
Okay, it's 3 minutes to noon. We'll take our lunch break at this time. Ladies and gentlemen, please do not discuss case among yourselves with anyone else. Do not permit anyone to discuss case with you or in your presence, and hopefully